Welcome everyone to the Landmark Chambers webinar on medical evidence in the asylum determination process. It's fantastic to see so many of you joining us for what I'm sure is going to be an extremely useful and informative session. My name's Galina Ward and I am chairing the session today. Your speakers are Dr. Bernie Gregory from Freedom from Torture and Samantha Broadfoot QC and Alex Shattock from Landmark Chambers. I'll introduce each of them formally in due course, but just a few housekeeping points to begin with. Your microphones are automatically muted, so you don't need to do anything on that front. We do very much welcome questions throughout the session. You should be able to see a Q&A box at either the top or the bottom of your screen, and if you could please use that to submit any questions that you have as we go along. We'll be answering as many as we can towards the end of the session. The webinar will be recorded. You will receive a link to the presentation and the recording shortly after we conclude today. If your connection is lost at any point during this webinar, we invite you to rejoin by just clicking on the original link again. So hopefully that's all quite straightforward. This seminar, I've said webinar, but that's just what a seminar is now really, is about medical evidence in the asylum determination process. It arises in part out of a joint working arrangement that Landmark has at the moment with Freedom from Torture, where barristers are providing legal review of medical reports. Obviously, it's not about influencing the professional opinion of the report writer, but making sure that the material and the opinions that are presented are put forward in the best way so as to assist the decision maker and of course therefore your client's case. And today we're going to hear about that process from both sides, both from Bernie's clinical perspective on what helps in terms of instructions and how you can best assist that process as lawyers, and then from Sam and Alex on the legal issues, what the case law says, and what general pointers lawyers can give to experts in terms of how to make their reports most useful. So without further ado, let's hear from our first speaker, Dr. Bernie Gregory. Bernie qualified as a medical doctor in 1985. She worked as a GP in the community and for a number of years in prisons. She's worked for Freedom from Torture since 2013, writing medico-legal reports for asylum seekers who've been tortured in their home countries. And we're delighted to welcome her, albeit virtually, to Landmark Chambers to speak to you this morning on the doctor's perspective in relation to medical evidence. Bernie.
Okay, thank you very much, Galina, and good morning to everybody. This is such a vast topic. It was difficult to decide exactly what to talk about in the 15 minutes I have, and discussing with colleagues. I'm going to talk quite a little bit about memory and trauma, as this is a really crucial area of medical legal reports. And I'm also going to talk a little bit about how we are trying to gather medical evidence during these times of COVID and lockdowns and so on. And then probably very briefly at the end, if I've got time, the best way that you as lawyers can help your medical expert. Right, so the reason I've chosen to talk about this is because there are a lot of very deeply ingrained myths about memory that certainly are there in the general public, they're there to a large degree in the healthcare service, but definitely ingrained in both the Home Office caseworkers and indeed a lot of judges in the tribunal. So the key ones that are of real relevance, I think, when writing medico-legal reports is this myth that memory somehow is like a digital copy, and when we recall our memories, we can accurately recall that every time. And therefore, if someone's telling the truth, then the story that they tell will be consistent each time. And by sort of reverse corollary, therefore, if there's differences in account, the person is likely to be lying. There's also a strong belief that memory of traumatic memories is so impressed in our memories that we can remember it all in very vivid detail. And that although we might accept it's difficult to recall some dates, if you've had a significant event, then you should really be able to recall the date of that event. So this is just a little picture representing that first myth. Your memory goes into your brain. There's a bit of jiggery pokery in the brain that sort of records it on some sort of memory chip. And then when it comes the time for you to recall that memory, out the memory comes exactly as it went in. But in fact, there are numerous factors that influence your memory, because memory isn't like this data computer section. Your memory is actually reformed every time that you recall it. And there are a wide number of influences that impinge on that process. So what comes out is more or less the same, perhaps, but there will be differences. And then the next time you recall it, again, there'll be some slight differences, and those differences may be different to the first time you recall it. So what sort of influences are we talking about? These are just some of the influences there. I'm not going to talk about all of those, but I would just highlight that first one, because it's something, of course, which is in our own experience, that the longer it is since you experience an event, the harder it is to remember that in detail. And yet commonly for asylum seekers, they're expected to remember events that occurred 5, 10, maybe even 15 years ago. And the other one I'll just pull out of that slide while you read down it is that third one about repeated events. As our memory is reconstructed, if an event has happened several times, so for example, if you thought back to a number of birthday parties you've had, your memory becomes blended. It becomes difficult to remember exactly what happened on each of those occasions. And as you reconstruct that memory, what you actually reconstruct is your sense of what normally happened in that event. So for example, with the clients that I see who are survivors of torture, if they've had repeated detentions or repeated torture events, it can become very difficult to remember exactly what happened on each event. And therefore, each time you give your account, you might muddle up where exactly a particular torture method occurred, in which detention. So as well as these different factors that influence your memory reconstruction, it means that every time you give your account, it's likely that there will be some differences. We know that there are some areas of our memory that human memory is actually just very poor at doing. And evolution hasn't given us the tools to have this accuracy within our memory. So again, I'm not going to talk about all the points in that slide, but you can see the sorts of things that we talk about there. But these are exactly the things that asylum seekers are asked about, both to verify maybe that the country they've come from, or to try and verify aspects of their story. And if those are incorrect, or they're slightly different on recall each time, it's seen as a strong indication for a lack of credibility. And for those of you who've read a number of asylum refusal letters or determinations, you'll see that this crops up again and again and again. That a corollary that somebody must be lying because they can't repeat what seem to be as fairly simple questions. And I will particularly just focus on that first one about dates. So there is a vast array of psychological evidence that shows our core memory for dates. The dates that we tend to remember are ones that are often repeated, for example, our birthdays or 9/11. I often can't actually remember what year 9/11 occurred at, but we can all remember 9/11. And in particular, for example, a study where people were asked about serious assaults that had happened to them within the last 6 months. Almost 30% of them got the date of that assault wrong. So even within 6 months, our memory of recalling a date is very poor. So that's all our normal memory. So you can start to see why it's so difficult to give these consistent accounts. But now we're going to layer in what happens in a traumatic event. So I'm not really expecting you to take note of this little diagram, but your normal autobiographical memory, that's your memory of events that have happened to you in the past, are normally encoded in an area of the brain called the hippocampus, which is that sort of blue, sort of wriggly centipede thing that you see on both sides of the brain. But at the end of the hippocampus is an area called the amygdala, which is a much earlier evolutionary structure. And our memories in fearful situations are still, and traumatic situations are still encoded within the amygdala. So if this is me in prehistory time, perhaps before I'm even a Homo sapiens and I'm out gathering fruit, I don't have a memory that this wolf came charging after me last time I was out foraging. But as I approach this area of woodland, I start to recognize, I just start to get overwhelming feelings of fear, of feeling of unease. As I get closer, I might suddenly get an image of flashing teeth. I might get a feeling, a noise of snarling, and I very quickly hot-foot it out of the area. So that's exactly what traumatic memories are like for many of our clients. So our amygdala memories are there, they're just sensory and perceptual snapshots. You don't have a sort of verbal narrative that you can tie all these memories together and then easily recount. And very importantly, these memories aren't marked in the past. So evolution is trying to say, you know, get out of there quick, there's something fearful happening. It feels that it's happening again at that moment. And this is a really characteristic area of re-experiencing that people with PTSD have. And again, very importantly, these amygdala memories can't be consciously brought to mind, but they're triggered by external cues. So that might be, in fact, a question, it might be a feeling you have. I find it's very common when I'm physically examining a client that when they look at a scar, it triggers a new disclosure of trauma. They'll suddenly say, yeah, that was a cigarette burn. Up to that point, they've never recalled that, that powerful image of seeing the scar triggers that recall. And in general, in traumatic memories, the central details are remembered more than peripheral details. I might remember a rape, I might remember roughly where it was, but I might not remember how many people are in the room, what month it was, even what year it was. Layer on top of all that, we're now going to put people in a very stressful environment of a Home Office interview or a tribunal. And their just basic level of arousal will be very heightened. And again, many of us will have experience of that. I have strong memories of taking exams where at the beginning you just feel you have this mental block. You can't bring that knowledge into your mind because you're feeling so anxious. And as you manage to calm yourself or get more into things, you can begin to recall things. And then a whole range of factors the interviewer will influence the way in which people can recall and narrate their memories. So I'm not going to go into that, but you can just read through some of those points there. Lots of physical things can affect memory. I've just particularly put in bold there about traumatic brain injury. Many of our clients will have been beaten about the head. Many will recall episodes of loss of consciousness. They may have had other types of suffocation, such as their heads being pushed underwater. And again, there's a lot of evidence that even with subsequent normal brain scans, just minor traumatic brain injuries can have very long-term cognitive effects, including effects on your memory. And then, of course, just mental disorders may have very specific effects on memory. And I just list PTSD and depression there as those being the most common ones that I see, but of course many other mental health disorders, anxiety disorders, psychosis may also have their effects. So I hope that just gives you a very, very brief flashpoint for yourselves to debunk some of these memory myths, to try and make sure you don't fall into those yourself, and feel more prepared to challenge the Home Office or tribunals, you know, if they're falling into those types of assumptions, and for you to guide your medical expert to be particularly commenting on these areas, particularly if credibility is being linked to differences between their accounts in any refusals that they've had to that time. So I'm now just going to speak just for a few minutes around medical evidence during COVID. Obviously, it's very much in our minds as we're all back in lockdown. And Freedom from Torture, along with many MLR writers, we switched to doing remote assessments, which we've had to confine to the psychological assessment. And we've done a lot of work in trying to gather feedback to see what the issues with that and how that might affect the quality of our reports. And this was important even prior to COVID, because the Home Office have already been working towards increasing use of video conferencing for asylum interviews, and we see that on a number of occasions. There are already had been remote hearings, and those certainly have restarted and no doubt will increase. But research shows that when you have remote hearings, adverse credibility findings are more likely. You're more likely, you're less likely to get bail. You're more likely to get a long sentence. And that's especially if there are particular factors that make the remote hearing difficult for the client. For example, hearing difficulties, other cognitive difficulties, mental health problems, or the need for interpreter. And I've put those two in bold because those are certainly extremely common with the clients that we see. And lastly, just not to underestimate that video is not perfect, sorry, not to estimate that video is perfect. And it is still difficult to make assessments of demeanour. So, you know, judges are taught they shouldn't be using demeanour assessments for assessing credibility, but we're human beings, it's very difficult not to do so. And trying to judge that on, for instance, eye contact is seen as a crucial one, but most of the time we're looking at different parts of the screen, we're not looking at the camera, and a number of issues like that. So I'm just going to very briefly, sorry, let's go back, run through some of the findings that that we found looking at the first 20 assessments we did, which in fact were all by telephone at that stage. That's because we had some issues with finding a secure platform, but we have also very importantly found that now we are using video more, that that's just not working for a lot of clients because they either don't have the correct device, they don't have the technical abilities for downloading apps and so on, and often they actually don't have access to reliable Wi-Fi, they don't have enough credit for data. So video certainly is not the cure-all for remote assessment, because there will always be a number of clients where telephone will still need to be a central part of that. So the main points to bring out is that issues around confidentiality, about 20% of our clients in fact weren't alone, whereas obviously face-to-face we'd almost always be seeing somebody alone in a room. Certainly issues with disclosure, so a third or so of clients reporting they didn't feel able to disclose certain things on the telephone. Opposed to that, about 80% said actually they had said everything that they wanted to, And there was a group of people who said they found the telephone was easier than face-to-face. It was less sort of, not confrontation, but less direct. In contrast, almost the majority, almost all the doctors felt that they hadn't obtained as full a history or the impact as torture as they do when they see a client face-to-face. And this was very largely due to the known vulnerabilities of clients, and then adding in that difficulty with unable to assess the visual cues of distress, and people being on their own in rooms, having little access to their GPs, for example, or counsellors, you know, particularly in the height of that first lockdown. It made doctors very reluctant to push clients to a stage where they become distressed, or you may trigger things like flashbacks. But in spite of that, the doctors did feel that they were able to make an assessment of the consistency of the psychological findings with the torture that the client had given, and that was perfectly satisfactory in about a quarter of those clients, and they could partially in another 60%. So valuable things could be said around these remote assessments, albeit with some of them with a number of caveats. And there were a number of other areas where detailed comment could be made, for example, around self-harm, around memory, which are you know, highlighting earlier the importance of that, around fitness to give evidence, particularly giving evidence remotely, and assessments of fabrication. But always we've recommended clearly face-to-face for the physical examination, but also to be able to update that psychological assessment with the benefit of an improved rapport and the visual cues that you get from a face-to-face assessment. So I'm running out of time, I think, but I'll just put these up for you to read, and you can have the slides. So there are challenges in using this evidence, and we need to be very mindful of that, so that the report writer is very clear about any limitations, but also ensuring that the decision makers aren't taking that more adversely than they need to. But clearly, we are all going to be changing our practice into the long term, I'm sure, now that we've got used to these remote type of assessments. And we hope that certainly, for example, detainees, asylum seekers who are in immigration detention may get more access to evidence, as may asylum seekers more generally, particularly if they are living far distant from a centre where they may be able to see a medical expert. And I'm not going to go through the physical side. Maybe if there's time, we could come back to that if that's a specific question. So I'm just going to spend very briefly of how you, members of this audience who are lawyers, can help your medical report writer. As you see, really, I've only got 2 of comments, and most support of those being good instructions. So every report writer is going to have a limited amount of time with their client. That's precious time. They need to know how to focus their questioning, and reality limited time in what they can write up. And you want a report that is really going to address the areas that are significant for the case that you are running for your client. So if it's a very straightforward pre-decision request for an MLR, it may be actually you just need very few instructions. But if you've got a complicated fresh claim, there have been numerous evidence perhaps in the past, it's really essential for the report writer to understand what it is that you want from them, so that they can write a report which will then give you what you need. And relating that, if you can please possibly get all the documents to the report writer prior to the appointment. I know that's not always easy, but again, getting documents after the event often means trying to contact clients again to put points to them and so on. and is always less satisfactory. And just finally to say that a very long list of cut and paste instructions that comes with every client, it is equally unuseful as very little instructions, because again, it's not helping your expert to focus in on what you really need from them. So that's all I'm going to say, and we'll just pass back to the next speaker and look forward to any questions on this. Thank you.
Okay, thank you, Bernie. That was fascinating as always, and I can see lots of really good questions coming up in the Q&A, which we will come back to at the end of the session. Your next speaker is Alex Shattock. Alex is one of our most junior tenants at Landmark, although they grow up so quickly these days. His practice covers the full Landmark range of public law, including, relevantly to this, asylum, deportation and unlawful detention. And he has particular experience working with vulnerable clients with mental health needs. He's one of our legal reviewers for freedom from torture, and he's going to speak now about what the case law in this field has to say about expert evidence. Alex.
Thanks, Galina. Hello, everyone. Right, so I'll be talking about 3 cases, but mainly just one, KV. It's a Supreme Court case, very recent, now the leading case on torture evidence. So there's a bit of a complicated backstory to this case, but it's well worth understanding, and the Supreme Court judgment isn't actually that long compared to other Supreme Court judgments. So I'd definitely recommend reading it if you will be instructing medical reviewers or medical experts in the future. I'm sure most of you are aware, but Sri Lankan Tamils are somewhat overrepresented in asylum cases with a torture element. There were a large number of instances of torture arising from the Sri Lankan Civil War, which was from 1983 to 2009, horrendous conflict. And I think everyone accepts the government of Sri Lanka behaved appallingly to ethnic Tamils, still highly suspicious of them to this day. KV was a Tamil claiming asylum and alleging torture in Sri Lanka. He had a number of scars as a result of being branded by a hot metal rod, to which the Secretary of State said, "We don't accept this as evidence of torture without a medical report," which is something we see quite a lot. So what KV did is he went and got a medical report, and he had that by the time of his appeal. However, his account of what happened in Sri Lanka was deemed to be inconsistent by the tribunal, but you can't really argue with a huge number of branding scars. So this posed something of a problem to the judge, but the judge's solution was, well, KV must have branded himself. I mean, how else would he have got all these scars? And when it was pointed out that it's quite difficult to brand your own back, the answer was, well, he got a friend to do it. This is wounding SIVP, or self-infliction by proxy. So the case was all about how you deal with allegations of self-infliction by proxy and what medical experts should do in terms of assessing whether that's a risk or not. The first-tier tribunal decision was dismissed on an error of law, which I won't go into, but the UT of the tribunal held that the case was an appropriate vehicle to provide guidance on medical scars caused by torture, and we had the Helen Bamba Foundation intervening. The UT dismissed the appeal in a 78-page decision, which is pretty large. I'd like to say I read all the paragraphs, but that would be misleading. The UT issued guidance to those preparing medical legal reports in relation to scars from asylum seekers who allege them to be a product of torture, where self-infliction by proxy is more than a fanciful possibility. Although in my view, I think it's always a fanciful possibility because it's just so unlikely. On appeal, the Court of Appeal said that, well, yes, it's so unlikely that it's inappropriate for the UT to issue that guidance. And I have some views on this, which I'll come back to later. But basically, the Court of Appeal disagreed with the suggestion in the guidance that medical experts should routinely consider self-infliction by proxy, even when it's not canvassed by the Home Office as a reasonable explanation. We're slightly unclear where we stand on this because, as we'll see, the Court of Appeal's judgment was overruled, not on this point, but I'll come to that shortly. The bit that was the subject for the appeal, and this is the key bit for us, was a strange part of the Court of Appeal's reasoning, where it said that the doctor strayed outside his remit. But what did the doctor say? He said he said that the branding was highly consistent with KV's account of torture, and he used the Istanbul Protocol wording. Now, if you're not familiar with the Istanbul Protocol, it's another document I recommend reading. It's a 1999 UN doc. The long title is the Manual on Effective Investigation and Documentation of Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment. And it's basically international guidelines on documenting torture. And it should be your guide both for writing these medical reports and also reviewing them. And on this highly consistent point, it's important to explain that KV said he fell in and out of consciousness during the torture. I believe he said he was unconscious when branded on the back and conscious when branded on his arms. And he had these rough, imperfect scars on his arms and these perfect brand scars on his back. And the doctor said, well, if you're branded when you're awake, you flinch and you twist. So the scar is likely to be rough and blurred. You can't get what's oddly described as a perfect, clean branding scar unless you're unconscious when it happened, which he said he was in respect to the scars on his back, and which were perfect scars. So those scars are highly consistent with the torture described. And the Court of Appeal wrongly said it was trespassing onto the tribunal's job to say that the branding was highly consistent with the account. And as I'm sure we all know, that's completely wrong. And credit to the government didn't try to defend this in the Supreme Court. The Supreme Court said that decision makers can legitimately receive assistance from medical experts if they want to offer an opinion about the consistency of their findings with the asylum seeker's account of the circumstances in which the scarring was sustained, not limited to the mechanism by which it was sustained. And of course that makes sense, because if the doctor's report had said this man has been branded with a hot metal rod, well, we know that. And going back to the Istanbul Protocol, which should be your first and last point of call when doing these medical reports or reviewing them, when linking the scars to what the Istanbul Protocol calls the trauma described, that means the victim's story. So a medical report must set out that story and must in effect ask whether the scars or symptoms described are consistent with that story. However, it's important not to go too far. The Supreme Court said that medical reports shouldn't say things along the lines of, well, I believe his account, or his account is true. We should recall that there are 5 levels of assessing consistency under the Istanbul Protocol, ranging from not consistent, which is a hard no, it couldn't have been, these scars couldn't have been caused by what was described, to, on the other end of the scale, diagnostic of, which means there's no other possible cause. And particularly if you fall within the middle 3 categories, which people often do, but really if you're in any of them, as a medical doctor doing one of these reports, you shouldn't be expressing belief or disbelief. Now you might think injuries which are diagnostic of the torture described means that the story must be true, but even that, if that's an inevitable conclusion, that final step, in my view, is properly for the decision maker. And it's important to remember the Istanbul Protocol has these requirements of objectivity. So it's important to keep an objective sort of view and an objective approach when writing one of these reports. And it will also make the report more useful to the tribunal and more likely to be believed if it comes across as neutral and impartial. Just turning briefly to SA, this was a contrasting case where a medical report didn't go far enough. In that case, the doctor basically went the other way and left out all the bits about consistency with the story on the basis that it was for the decision maker to make that call. But the Court of Appeal said, no, that's wrong, and offered this useful passage about what a scarring report is for. What you're actually trying to achieve here is a clear statement as to the consistency of old scars found with the history given, directed to the particular injuries said to have occurred. So if you're writing or have commissioned a medical report, it's important to make sure that report addresses the key questions. What does he say? What does she say has happened? These are the scars or the symptoms. These are the possible causes. And then crucially, is what you see consistent with what's being said about what occurred? But obviously follow the wording of the Istanbul Protocol closely when writing that decision. There's also some useful pointers in this case about possible alternative explanations. If there is a possible alternative, you should always be aiming to put that in, if only to cut it off from the point of view of the client. And if there's anything that might distinguish between whether it's one cause or another, that detail should be put into. Final case, very briefly, and I only put this one in to emphasize that a good medical report can make or break a case. This was a Strasbourg case about ill treatment in police custody. There was a detailed medical report provided, and Strasbourg court said, well, that's conclusive then. No credible alternative offered. He suffered the ill treatment, violation of Article 3. So just the simple point is, it is important to get a medical report right, and if you do it properly, then that can be your case. And again, the court referred to the Istanbul Protocol in this case too, so you should have that document firmly in your mind when writing or checking a medical report. So what are the takeaways? I've mentioned it a number of times. Istanbul Protocol, that's really important. Make sure you've got that in mind. Consistency with the account is a matter for the experts, but don't go as far as saying you believe them. And one final thing, which I promised I'd return to, self-infliction by proxy. It's not clear where we are with the guidance on this. I think the Court of Appeal is right to say it's usually vanishingly unlikely. But I always advise experts to put in a paragraph on this anyway, because there will be one judge who thinks it might be possible, and you want to cut that idea off before it becomes firmly implanted. So even if there's no suggestion of self-infliction, I think it's usually, just to be on the safe side, I'd recommend putting just a sentence or two at least on that. And the Istanbul Protocol also says you should offer an opinion on whether wounds were self-inflicted. So in my view, do it. And that sort of links to mental illness symptoms like PTSD. Same again, in my view, it's important to say what the chances are of the victim making it up, because there's a misconception that it's easy to fake mental illness symptoms, when often those symptoms are quite specific, and you have to have a very good knowledge of mental illness to be able to fake all of those symptoms consistently. So when writing a report or reviewing a medical report, in my view, there should be at least a brief section setting out what are the chances of these symptoms being faked, and often the chances will be quite low. Right, that's the end of my talk, so I think I'll pass on now to Sam.
Okay, thanks very much, Alex. Our final speaker this morning is Samantha Broadfoot QC. Sam is a vastly experienced public lawyer. She's highly ranked in this field in all of the directories, and she's regularly acted for both the Home Office and particularly in Silk for asylum seekers as claimants or as appellants. She's asked me to say that although she does act for both sides, it's never in the same case. Sam is also part of the team reviewing reports for freedom from torture and has cast her legal eyes over several reports in the last year or so. And she's going to give you some practical tips on how to ensure that a report has maximum impact.
Hello, good morning, everybody. Expert reports, experts and indeed their reports are an incredibly valuable resource, and I'm sure that many of you will be struck, as I was, although I've heard Dr. Gregory's talk before, about how incredibly important it is to understand the value that can be added, particularly in understanding memory and how memory works. The aim of this talk is to try and ensure that the medical reports that we manage to obtain for people have the maximum possible impact, because as we all know, it's often very difficult to get one. And so if you're in a position where the Freedom from Torture or another body has taken on your client and is willing to provide a report, let's make sure that it has the best possible impact. So in that context, I've put together 8 top tips. I've had cause to see many medical reports over the years at the bar, and as Galina said recently, I've also been working as a reviewer and looking at Freedom from Torture reports. And the interesting part of doing that work is that actually I see what the medical expert actually receives, whereas when you see a medical report as a barrister in a case, usually it's done and dusted and finished, and you don't often have any input. So what follows is a very brief distillation of my experience. Tip number 1 then, structure. I've seen reports that look like a narrative flow. There are 2 problems with this. The first is that it's then hard to navigate the report, and the second is that it's very difficult to ensure, or easily to ensure, that everything that's required to be in it for maximum impact is in fact there. So what is required? There's a specific practice direction 10 in the asylum context, and you can use the requirements set out there as part of your structure. And I've noted obviously that the civil context is in part 35, just for reference. So practice direction 10.9, an expert's report must, and then there's a list. Give details of qualifications, give details of any other material or literature, etc. I won't read them all out. You're all able to see those for yourself. What is missing from that list, however, I think is probably 2 things which is useful in the context of structure. Firstly, methodology. And now in the asylum context, that is particularly important in 2 ways. Firstly, of course, it's important to know how long the medical expert spent with the individual, because very often it is considerably longer than anyone else has spent with the individual, and certainly the Home Office and possibly also the solicitors instructed with the case. And what struck me by looking at all the Freedom from Torture reports for review is how many hours is often spent. And I think that's particularly important to make sure that that's noted down, and certainly the FFT reports always do. And then the second thing is it's important to set out how the interview has happened, particularly at the moment where, of course, they're not face-to-face, because that enables the expert to be reminded to say, well, what is the impact of having done these interviews, perhaps in sections over X number of hours remotely. The next tip is set out the very basic key information right at the beginning. So the FFT reports, for example, in their standard format, always do this extremely well, and they set out in a table or a box on the front page key details about this individual. That's very useful for anybody looking. It's very useful to know exactly what documents the individual has, the expert has had access to, and the dates of them, and it provides a sort of anchor to the very basic factual information about the context of the report and the asylum seeker in question. Use headings that may be self-explanatory, may indeed be obvious, but it doesn't always happen, and it makes it easier to navigate the report. And of course, underlying all of these tips really, how do you get maximum impact, is the fundamental principle, which is the easier you make it for the reader, the more likely they are to accept the contents of the report. And of course, the reader will sometimes be the Home Office if it is a pre-decision report, but very often it is the first tier tribunal judge if the report is to be considered in an appeal. Typos. Please be aware of errors that happen as a result of cut and pastes. The gender of the asylum seeker, for example, is a common error. But other typos that solicitors can perhaps expressly keep an eye out for is perhaps non-standard reference to tribe names, place names, or other factors like that, where the expert may not know necessarily or immediately the received way of referring to Al-Shab or some other group, for example. Language. This is key. The top tip is to try and keep it neutral where possible. And there are words which you sometimes see in medical expert reports, which are terms of art, such as persecution or torture. Now, if the individual is describing their experience, I was tortured, and it's a quote from what the individual has said, then that's fine, but make it clear that that is what the individual is saying. On the other hand, I always try and steer experts away from using the word persecution or torture, because it can be seen to be usurping the decision maker's function, because technically what the medical expert is doing is documenting injuries or other clinical findings which are evidence of torture or persecution, and whether or not they are or do amount to torture or persecution is primarily a matter for the decision maker. And I sometimes find that where a medical expert liberally uses the word persecution or torture, for example, that it gets the judges back up a little bit. And so hence I say try and keep it neutral where possible. Use the terminology of the expert's own field with lay explanations. This is particularly important where it's technical clinical diagnoses. Avoid superlatives. That's advice I have to give myself when writing a skeleton argument all the time. And an expert should avoid using phrases like, I would argue that. No, the right phrase is, in my clinical judgment, or in my opinion, or whatever it may be. So if tip number, tip 6, sorry, is solicitors make it easier for the expert. And Dr. Gregory touched on this. Please provide documents, provide them in good time, and spend a little bit of time thinking about what you want the expert to do. I have seen a number of what I can only describe as very standard instruction letters, which are really very unhelpful. And one of the functions that the legal reviewers have had to do, and I've had to do this sometimes, is try to unpick actually what are the issues likely to be in this asylum case, and therefore what help can the expert give you. So make it easier for the expert. Their job is already very difficult, so help them and you'll get more out of it. And don't forget to specifically mention that their opinion is sought on the impact of the asylum seeker's mental state on their ability to recall events or sequences of events with precision. Now, this obviously feeds straight into Bernie's talk, Dr. Gregory's talk about memory, and definitely make sure that a question about that is included. So if the headline of tip number 6 was solicitors make it easier for the expert, really the headline for tip number 7 is experts make it easier for the judge. And the top tip in respect of that is that obviously the expert is not the advocate, and an expert that gives the impression of being anything other than impartial will have little credibility. Finally, don't forget the formalities. The declaration, i.e. that the expert knows that they're overriding duties to the court and not to the individual who's instructed them, and that, of course, that the opinion is their complete opinion, etc., etc. The statement of truth and a signature. So those are my top tips. Thank you very much for listening.
Thank you, Sam. I think if all the panel can come back on, including Dr. Gregory. That would be brilliant. Thank you all very much. So we've had a number of questions in the Q&A box. I think there's several for well, for all of you. I wonder if perhaps the first one that might be helpful to the number of people have raised is what your views are on remote hearings, and what, if anything, could be said in favour of, or indeed to oppose them in a particular case. If we start with Sam, maybe. Sam, you're on mute.
Sorry. Yes, hi. Yes, thank you for that. I have not had to do a remote hearing involving live evidence. So in that respect, I've been quite fortunate. But there has been a fairly detailed, I think they call it a fast report, I think by the Ministry of Justice on remote hearings, and it came out, so an overview of remote hearings, I think it came out at the beginning of the summer, which I read and is well worth reading, because it does identify that although there are obviously some positive aspects to remote hearings, there are also a number of difficulties with it. Insofar as experts giving evidence are concerned, I think that experts are capable of giving good evidence remotely. That would be my view, subject to anybody who's got different experience. But insofar as individuals and asylum seekers are concerned, I would have thought that there must be a lot of difficulties with that. And so probably what I would do is I would start with looking at the Ministry of Justice's own overview, or the court service's overview of it, if one was going to oppose that. And then obviously Dr. Gregory spoke about their assessments, their review that they have done, and I would look at that as well to see whether a good argument, a very persuasive argument, can be made for avoiding a remote hearing.
Thanks, Sam. Building on that, perhaps, Dr. Gregory, that we've had some questions about the difficulties of, as you touched on, assessing vulnerable clients remotely, particularly if their claims dependent on all about their mental health and their past experience of torture. And well, first of all, what suggestions you have for those, because you highlighted a number of difficulties with those assessments. What are there any suggestions while we're still in this position of making things better or easier?
Yes, so I think for the medical expert, it's being about upfront about what issues have been raised in the report, in getting that account remotely. And I find actually I can often turn it to my benefit, because it actively demonstrates the mental health status and issues of that client. So, you know, it should be that face-to-face or on the phone if people have difficulties disclosing. I can often draw really strong evidence from that to talk about in terms of the client's mental state. So we certainly wouldn't be pushing clients to re-traumatize them. However, having said that, you know, having some account or a broad account clearly is beneficial for a client. So one of the things we found is that, so we had as a standard done our assessment over 2 phone calls, and often the second phone call gained a lot more detail than the first. You'd already established some rapport. The client knew what to expect. Neither of us were fiddling around with the technology. And I found that was very common to get more details on the second call. So, for example, if you were trying to take a witness statement, maybe just factoring that you might do that over a number of calls. So indeed, quite often we'd have a third call maybe to clarify specific issues. So that would be one practical tip, is about trying to spread that out. Obviously, that's not going to be a practical tip for someone in a tribunal hearing. And just so most people's well, not most, a lot of difficulty with disclosure is around trust, and therefore just still trying to create an environment of trust with the client, explaining, you know, who you are, why you're asking those questions, constantly reassuring them why you want the detail, that they don't have to give it, that they can give it in their own time, that we'll take a break whenever they need it. We can do it on another day if they can't cope now. You know, things like that, which really we do face-to-face as well, but it is just even more important on the remote type of environment.
Sure. Thanks for that. We've had a number of questions. This could be for, I think, maybe anyone on the panel really, about terminology in reports. A specific question from Desiree Sadiq about how an expert should frame and use the term trauma in a report, and other questions about similar use of language. Does anyone have anything to contribute on that?
Well, I can say something on that. Yes, thanks, Galina. Just in terms of terminology generally, I think if there's any potential ambiguity as to what a term means, I think it would be useful if the expert report says what it means when it says something like trauma, for example. So I think that applies to whatever terminology you use, particularly if there's scope for disagreement as to what that term means. But on trauma generally, I think KV was fairly clear that what trauma means in the context of the Istanbul Protocol is the trauma described is the account of the torture, effectively. So when you're referring to the trauma described, that should be the victim's account of the torture.
Great. Another question that's come up is what Dr. Gregory said about memory. To some degree, is obviously of general application. I mean, you've given us a very clear explanation of how memory works, which is universal. Is there any scope for having for relying on reports that aren't specific to the individual's case? What do members of the panel think about that? Sam, maybe?
Yes, thanks, Galina. It's fascinating, isn't it? Because actually, the more you read about how memory works, and indeed the potentially the inadequacies of live evidence, the more you start to wonder in the ability of a system to actually get to the bottom of it and of the truth. And I think perhaps we've reached a point where the system isn't perfect, but it's the best we've got. And I think that whilst you can try to make a submission a generalized submission about memory and how it works, the potential implications are so far-reaching that I think that judges are not going to say or accept that just as a matter of general principle, that they can't make any adverse credibility findings because memory is inherently unreliable. That's just not going to happen. And so given that in the most impactful aspect of this will be in circumstances where you've got clinical support via an expert of injuries or trauma or mental health condition, it's in that context. So you'll need some expert evidence anyway for a clinical diagnosis of a mental health condition, whatever it may be, that at that point the expert may as well and should be asked to also include an explanation about the effect of this mental health condition on the ability to remember things accurately.
Thanks. Dr. Gregory, do you have anything to add on that? I mean, in particular about sort of the read across from general principles to reports and individual cases? I think you're still on mute.
Sorry, I thought I switched it off. Yeah, no, I'd agree with Sam that, you know, what I often advise report writers is it really has to be about that individual. So beware cut and paste in that view. I'm not saying I never cut and paste, but if you do, you really need to make sure it applies to that person, to that client. And so then, yes, I do make general comments about, you know, memory in general that affects us all, but then I will really drill it down to the examples that are applicable to that client. So I will ask the client, you know, how you say your memory is bad, how does that affect you day to day? And pick out the places in the documents where there may have been differences in the accounts have been picked up and ask them about that. So I'm always trying to get it down to the specifics of the client. And I think in terms of an impactful report, that's of much more importance.
Thanks. Just while we're on what reports should cover, we've got a question just come in about commenting on medical facilities in country of origin. So where the Home Office is suggesting that a client could receive treatment for particularly mental health conditions in their own country. I mean, that's obviously slightly different to the focus of freedom from torture reports on whether, on evidence of torture, but is there scope for dealing with both in the same report?
I can comment on this one, Galina. It will depend on the facts, I think, but I had a similar case to this where one of my clients from an Eastern European country had treatment-resistant schizophrenia, and it took 10 years to get the right medication in the UK. So under those circumstances, I think you wouldn't need much knowledge of the healthcare system back where he came from to know that it'd be very difficult to give him the kind of treatment that he needed back there. But that's, I think, probably a different case to when you're asked to make general comments about the healthcare systems in other countries, and if the expert doesn't have any specific experience of what the healthcare system like is in a particular country, unless you have, you know, a case where there's obviously going to be some difficulty because it's a very, very difficult mental illness to deal with, and it needs a very specific kind of medication, then I think it probably isn't wise to go into the area of speculation, because that undermines the credibility of the report overall if you don't have a firm evidence base for what you're saying.
Absolutely. So you're really looking for a different report from a different expert who is familiar with the healthcare system in the country of origin, not trying to get an opinion from someone whose expertise is something very different.
Absolutely.
That's really helpful. I think we've probably got time for maybe one more question. So apologies if we've not got to yours, any of the people in the audience. There's a question on interpreters, and just whether, I think it's probably the last one, whether anyone has any hints or tips for dealing with the risk that interpreters have either perhaps inhibited full disclosure from, or caused the client to feel inhibited about making full disclosure, or possibly due to an experience not fully interpreted what they've said. Has anyone got any strategies, tips they can share on how to deal with problems with interpreters?
Shall I take that?
Please.
Yeah, so we are really fortunate at Freedom from Torture that we generally have excellent interpreters. But, you know, I do a lot of work with interpreters in the world out there as well, and often you know, see a whole variety. My top tip would be to say to brief the interpreter before you start, because you will start to get a sense of the interpreter. You want to be clear, you know, what you're going to be doing, what you're trying to achieve. And again, we debrief at the end so that you can get a sense of what the interpreter has felt themselves, and whether they're saying anything inappropriate about that. Very rarely we've changed interpreters, so say if we're seeing someone twice or 3 times, if the client is raising issues with the interpreter, then we may change the interpreter. And sometimes that is just the perception of the client, because they feel they're either from a group that doesn't understand them, their own maybe slightly different dialect. But if that is inhibiting the person disclosing, that may be something to consider. But again, as the person listening, I think all of us who've used interpret have the experience of some great long conversation between the client and the interpreter, and the interpreter says, "Oh yes, he says he did." And so you need to sort of say, "No, you know, you need to tell me exactly what he said," as you know, as far as possible, using the words that he said. So I think you usually do get a sense if you're not getting the full story, if you like. But I think it certainly helps that pre-briefing, just a few minutes before you start, will help the interpreter know, what to expect and what's expected of them.
That's really helpful, thanks. So I think we've run just over our time, so I think we're going to have to wind it up now. But thank you very much to all of the panel. That's been massively informative, certainly for me. So there's a lot to think about there. For members of the audience, as I said at the start, the session has been recorded, and that will be circulated with a copy of the slides. And if you lose that email for any reason, the slides will also be on the Landmark Chambers website resource bank if you need to refer to them in the future. So thank you very much, everyone, for dialing in, and I hope you have a good rest of your day. Thanks, everyone.